Good morning and welcome to the Board of County Commissioners Land Use Meeting. Today is Thursday, September 25th. I appreciate your patience while we got started a little bit late this morning. We had multiple commissioners at an event, and sometimes it's difficult to get back in that traffic. So I appreciate your patience. We do begin each of our meetings with an invocation, and this morning we have Travis Williams from Springs Rescue Mission. We do invite you to stand and join us if you'd like.
Thank you. Heavenly Father, we gather today in gratitude for your presence and for the privilege of serving this community. You are the source of truth, beauty, and goodness, and we ask that those gifts guide every decision made in this room. Thank you for the blessing of freedom and for the ways neighbors, churches, and businesses can come together to build a stronger community. May that freedom always be stewarded wisely and used for the good of others. I lift up these commissioners, grant them wisdom, humility, and courage, shape their leadership through service, stewardship, and sacrifice, so their work honors justice, protects dignity, and promotes flourishing for all who call this county home. We remember our neighbors, families raising children, veterans, workers, and those carrying heavy burdens of poverty, addiction, or homelessness. May this be a community where neighbors love bigger, hope multiplies, and lives are restored, one neighbor at a time. Bless this meeting, bless these leaders, and bless this city. In Jesus' name we pray. Amen.
Commissioner Weissong, would you lead us in the Pledge of Allegiance? Item 3.
Item number 3 is staff emergency items, and I'm unaware of any staff emergency items today.
Item 4.
Item number 4 is changes, postponements, and notice of the next meeting. I'm unaware of any changes or postponements to today's agenda, and the next meeting will be Tuesday, September 30th at 9:00 a.m.
And before we move on to, actually, I'll do item 5 first. So do we have anyone here who wishes to speak on an item not scheduled on the agenda? Okay, I see no one in the room, and I see no one online. Before we move to item 6, I will ask for a motion to excuse Commissioner Williams.
A motion we excuse Commissioner Williams.
Second.
It's been moved and seconded. I'll call the roll. Commissioner Weissong,
Aye.
Commissioner Nelson,
Aye.
Commissioner Applegate,
Aye.
and the chair votes aye. That passes 4-0. Item 6.
Item number 6 is a special district service plan, Antler Creek Metropolitan District, a request from Antler Ridge LLC for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for the Antler Creek Metropolitan District. The 244-acre area included within the request is zoned RR 2.5 residential rural and is located north of Ayer Road, south of Latigo Boulevard, and east of Meridian Road. The service plan includes the following: a maximum debt authorization of $10 million, a debt service mill levy of 50 mils for residential, an operations and maintenance mill levy of 10 mils, and 5 mils for special purpose, for a total maximum combined mill levy of 65 mils. Covenant enforcement is requested. The Planning Commission recommended approval 6-0. There is no public opposition to the request. Parcel number 42180000022, Commissioner District number 1, file ID 25003, Carrie Parsons, Principal Planner, Planning and Community Development.
Good morning, Commissioners. Right, thank you, Ms. Alred, for reading that into the record. Okay, sorry about that. Great. If there's anybody watching this item and you would like to participate, if you could please email pcdhearings@elpasoco.com and we will get you into the queue to speak on the item. All right. This is a slide of our hearing procedure for those of you watching remotely. Presentation will be made by staff, and then the applicant. The chair will call for public comment, potential rebuttal, and then questions for staff or the applicants, and then, of course, back to the dais for the board's vote. More specifically, this request as read into the record. At the time this went to the Planning Commission, it was zoned agricultural or A35. Since Planning Commission, the Board of County Commissioners did go ahead and approve that map amendment or rezoning from A35 to rural residential 2.5, which then would be supported in the financial plan as an exhibit to the service plan before you. So that condition has been met, that the rezoning has been approved by this body. The mandatory criteria for disapproval is on your left, and then the discretionary criteria for disapproval is on your right. And I'll leave that on hold so those in the audience and online watching can glance at those. Right. The purpose of the district is very typical within the statutory provisions, and you see those listed on your screen, and of course in the backup. There is nothing unusual about this service plan. Again, the history of this, as I mentioned, the board recently approved that rezoning or map amendment, and so there is no issues with the overall service plan not having the underlying land use as indicated in the staff report originally written with Planning Commission, because that was approved. Current zoning, again, I'm sorry, it still shows A35 on our zoning. It takes a quarterly update with GIS, but this property has been rezoned RR 2.5, which is consistent with those properties to the east and to the south. Current mill levies on the property about 72, proposed would be about 137. Master plan, as you are quite well aware, supports special districts so that development pays for its own and not the county taxpayers outside of the development. It is also large lot residential. The finding of consistency with large lot residential place type was made by this body during the map amendment. Summary of the application. The district is not anticipated at this time to provide urban services for water and wastewater. It will operate on well and septic or on-site sanitation systems. However, the district would have the power to report the well usage and metering to the state as a provision of its authorities. The district also will not be providing fire hydrants for the Falcon Fire Protection District to use. It would be able to provide fire cisterns for the use by the Falcon Fire Protection District under the provisions of the service plan. And there are no other entities located within the development that are capable or willing to provide the services, which is the applicant's justification for the need for this particular service plan approval. And as indicated in your staff report, typical service plan infrastructure that the district would eventually be design, constructing, and financing: roadway, drainage, landscapes, park and recreation. The 30-year bond term still applies, although in conjunction with the recently adopted state law, a 40-year is the maximum debt term overall for the district. And if there are no further questions for staff, if there are no questions for staff, Chair, I'd like to get your permission to call up the applicant.
Are there any questions for staff? Commissioner Applegate.
So it was zoned for agricultural 35, rezoned RR 2.5. That's residential rural 2.5 acre lots, correct?
Yes, sir.
Okay, thank you.
You're welcome.
Any additional questions for staff? Commissioner Nelson?
I'm still learning, so humor me in this question. With the well and the reporting to the state, is it that this development are making the request for the lots to have wells, or will it be the property owners that are having to go to the state to receive those rights?
Great question. So, Chair, if I may expand on this. Okay. So currently, we're at the stage of the rezoning has just occurred, and we don't consider water sufficiency or water supply based on our current approval criteria for a map amendment or rezoning. However, it is anticipated, based on the size of the lots and conversations with the applicant, that this property will be served by individual wells.
So sorry.
It's okay. And on-site septic systems. So we are anticipating a preliminary plan, which we have in review right now, that identifies individual wells will be used and on-site septics. I don't believe we have a finding of sufficiency wrapped up yet, and it will be wrapped up before it comes to this body for a preliminary plan. And that is when the board will have attached to the preliminary plan packet the finding from both the state engineer for water sufficiency and the county attorney's office for water sufficiency at a 300-year level. Even though it's on a well, it will still have that 300-year level support. In addition to that, it's very typical that the county attorney will have language in her letter stating that there's conditions for the HOA, or in this case, the HOA will function as the district, to provide monitoring if that's what the state engineer decrees. Does that answer your question?
Yes.
If not, I'll look to Lori for a more exact answer, but if
No, that was great. Thank you.
Okay.
I realize it's not necessarily part of our criteria for today, but it was more of my own just curiosity and wanting to understand the bigger picture, and that we'll take that into consideration at a later date. But thank you.
Anything else? Okay. That's what I did down there. Yeah.
Thank you so much. Good morning, Commissioners. Alicia Corley from Icenogle Seaver Pogue on behalf of the applicant for Antler Creek Metropolitan District. We have representatives here from the developer owner as well as our financial team should the commissioners have any questions that I am unable to answer. Lori showed you, I'm sorry, not Lori, Carrie, showed you a vicinity map of the location of the district, which is shown here in front of you. Project information, some of this Carrie covered. We're anticipating 244 acres to be developed into 84 single-family residential lots. As Carrie mentioned, this was approved by the Planning Commission for a rezone, so it is currently zoned at RR 2.5. The timeline for the special district would be following today's hearing. We would go to the court and ask for an election, which would be held on November 4th of this year, and then we would get an order from the court following that election organizing the district. This is a map which shows you the infrastructure that the district would be constructing. Here's a summary of metropolitan districts generally, and Carrie mentioned some of this in her presentation. Title 32 special districts are here to serve a public use. Instead of the county paying for the infrastructure, the residents in this neighborhood would pay with a reduced home price. The benefit of having a special district is that the district can issue tax-exempt financing to pay for this public infrastructure, and it's a very common practice here. This district would have ongoing responsibilities. Initially, it would fund public improvements consisting of roadway and drainage facilities, ongoing maintenance and enforcement responsibilities. There'll be 8 stormwater quality ponds, and then maintenance associated with Black Squirrel Creek. And then, as Carrie had mentioned also, there would be covenant enforcement undertaken by the district. criteria for special district service plans Carrie showed you during her presentation. There's also the El Paso County Model Service Plan, which we have utilized here and met, and staff has no outstanding concerns with the service plan. This details the limitations in the service plan. We've asked for a maximum debt authorization of $10 million. That's based on public improvement costs of approximately $8.6 million. And there is a little bit of cushion to allow for inflation and contingencies, changes that may occur from the date of approval of this service plan until the improvements are actually constructed. The maximum debt mill levies are listed here and are consistent with the county's model service plan: 50 mills for debt, 10 mills for O&M, a special purpose mill levy of 5 mills for an overall cap of 65 mills. And here I need to bring to your attention an error that we have in our service plan. So in the service plan, it states on page 14, and it's something I would like to correct today, that we have 5 mills, and then in parentheses it says 0, which is incorrect and inconsistent. And then there's a location where the total is listed as 60 and it's 65. So everything in the staff report and every other location in the service plan, but our financial team noticed that typo today, and I apologize that during this whole entire process we have not noticed that typo before, but it is something that I would like to be able to correct in the service plan and have that on file with the county. Sorry. In addition, the service plan contains the annual report requirement and a disclosure to prospective purchasers. And then we have this language as well, that approval of our service plan does not in any way imply land use approvals. That will be a separate process that the applicant will have to go through with the county. Carrie mentioned this, and I didn't do a great job of explaining this last time when I was before you, but we have this new legislation that was passed that requires a 40-year debt mill levy imposition term for residents. That language is included in your service plan, in addition to the language that you already had in your service plan regarding a 30-year maturity. And Carrie had explained it better than I did last time, that with the 30 years you could refinance and it would actually extend the debt mill levy imposition term. But now we have this new legislation, and the debt mill levy imposition term will not extend beyond the 40 years. These are the service plan criteria that our service plan meets today, that you must find in order to approve the service plan, and I'll go over these on the next slides. Number 1, there's sufficient existing and need for service in the area to be served by this proposed special district. There's a demand for housing. The special district would undertake construction of the public improvements to serve this development. Will also undertake maintenance of some of those public improvements in perpetuity and provide covenant enforcement for the neighborhood. Number 2, inadequate existing service. The existing service in the area to be served by the district is inadequate for present and projected needs. As Carrie had mentioned, there are no other governmental entities located in the vicinity that consider it desirable or feasible to undertake these improvements, and the district's going to provide the funding for the initial construction of the improvements and then continued maintenance of the improvements. The third criterion is that the district is capable of providing economic and sufficient service to the area. Estimated future costs are in line with comparable districts, and the next slide shows you where the mill levies fall in comparison to other districts. The district's going to provide adequate and perpetual maintenance of public improvements, and then we have a financial plan attached to the service plan, which demonstrates the ability to discharge the debt. This is a slide that I mentioned that shows the surrounding residential metropolitan district mill levies, and highlighted is our proposed district, Antler Creek Metropolitan District. And the last criterion, which we've satisfied today, is the area to be included in the proposed special district has or will have the ability to discharge the debt. And as I just mentioned, that's demonstrated by the financial plan, which is attached as an exhibit to the service plan. This is a detailed slide that talks about the bond structure and repayment, and I will summarize the model included with the service plan anticipates an initial bond issuance in 2027. That would be with a 30-year term and a final maturity of 2057. Since it's an early stage issuance, there would be a market study, a financial forecast, and the bonds would be sold to institutional investors. The model then projects that there would be a refinancing in 2037 to repay any remaining developer reimbursement obligations and then refund those 2027 bonds. And we have a financial advisor here today should you have further questions regarding the financial plan. And as I mentioned at the beginning of the presentation, the next step following today's hearing before you would be to go to the court to get an order for an election in November, and then we would seek an order organizing the district before the end of the year. And I am happy to answer any questions.
Commissioner Wysong.
Thank you, Madam Chair. Maybe I missed it, but who is providing gas and electric?
I do not know the answer to that question.
Good morning, Commissioners. Craig Dowsey of Vertex Consulting. Commissioner Wysong, it'd be Black Hills and MVEA in that area of the county.
Okay, thank you.
Any additional questions from commissioners? Commissioner Nelson.
Just a comment. You did a fine job presenting last time. That was my fault.
Oh.
I misunderstood during my orientation something that was said. And so I thought El Paso County had more restrictive guidance on debt limitation, extension of timing. And so you did great. It was me that was confused. So
Thank you for saying that. I appreciate it. So I was a nervous wreck.
no, you were fine.
Carrie did a great job explaining that.
Correcting me. I am curious, who is it, again, I'm learning, so humor me. Who is it that will be voting in the election?
So in the initial election, it's the eligible electors, which would be representatives of the developer until the
lots are
project is.
sold.
Mhm.
Okay, so none of the lots have been sold yet. This is very early stages, and so the ballot will only be the people who currently own the property, which is the developer.
Yes.
Okay, thank you.
Okay, I think that doesn't look like we have any more questions at this time, unless you have something else you'd like to share with us.
No, I just would like to ask for the ability to make those corrections in the service plan. It's on page 14, and I can get with Lori after the presentation should the board decide to approve the service plan.
Okay,
Thank you.
thank you. Okay, just make sure that staff doesn't have anything else at this time. And so we can move to the public input portion. So we begin with those who are here to speak in support. So if there's anyone here who would like to speak in support of this application, I'd ask you to come forward at this time. I see no one coming forward in the room, and we have no one online. So we will move to anyone in opposition to this application. So if there's anyone here who'd like to speak in opposition to this application, please come forward. And seeing none in the room and none online. Typically we would go to a rebuttal, but it does not appear there's anything to rebut. So I'll just ask, do you have anything else that you'd like to add at this time? Okay, commissioners, do we have any additional questions for staff at this time? Okay. Well, we will close the hearing and I will bring it up here for comments, any discussion and a motion.
I'd like to make a motion approving the special district plan for Antler Creek Metropolitan District.
Second.
Because we had a request for some changes as it was included in the packet. I'll look to our clerk. Is it sufficient if we ask the commissioner to amend his motion to include those items?
Yes, please, if we could incorporate that in the motion just so we can add those requested changes.
Okay, let me redo that then. motion to approve special district plan for the Antler Creek Metropolitan District with the corrections that were made by staff.
Second.
Okay, that has been moved and seconded. I'll ask one more time if there are any additional comments. I will call the roll. Commissioner Weissong,
Aye.
Commissioner Nelson,
Aye.
Commissioner Applegate,
Aye.
and the chair votes aye. That passes 4-0. Thank you. Okay, we will move to item 7.
Item number 7 is a special district service plan, Triple H Metropolitan District numbers 1 through 3, a request from Monson, Cummins, Showit, and Fair LLC for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for the Triple H Ranch Metropolitan District numbers 1 through 3. The 760-acre area included within the request is zoned RR 2.5, residential rural, and is north of Jones Road, south of Falcon Highway, west of Peyton Highway, and east of Murr Road. The service plan includes the following: a maximum debt authorization of $37 million, a debt service mill levy of 50 mills for residential, and an operations and maintenance mill levy of 10 mills, and 5 mills for special purpose, for a total maximum combined mill levy of 65 mills. Covenant enforcement is requested. The Planning Commission recommended approval 6-0. There is no public opposition to the request. Parcel numbers 3300000388 and 168, Commissioner District Number 2, File ID 25004, Carrie Parsons, Principal Planner, Planning and Community Development.
Thank you, Ms. Allred. All right, if there's anybody in the audience that would like to participate in this hearing, if you could please email the clerk at pcdhearings@elpasoco.com. This is for the Triple H Metropolitan District numbers 1 through 3. Again, the hearing procedure for this particular item is the same as was presented before. Presentation by staff and applicant, public comment, potential for rebuttal, if any, questions for staff or applicant, and then, of course, back to the dais for a decision. This request is a little bit different than what the board has seen before. The request does include the standard provisions of a special district with maximum debt of $37 million, 50 mills for residential, 10 mills for residential for operations and maintenance, and 5 mills for a combined mill levy of 65. However, this also does include authority for the districts to form a special improvement district, or a SID, to assess the property. I did provide a detailed presentation that the applicant provided on SIDs, or special improvement districts, to your backup material. But in a nutshell, I will speak very briefly to this and then defer to the applicant. It is my understanding that the special improvement district would assess liens on the property after the time of final plat, potentially, and those liens would have to be paid off by the developer or interested parties prior to the developer selling those individual lots to the end user, custom home builder, lot owner. For any other detailed questions on that, I would request the board kindly to defer to the applicant, because I'm not the expert on SIDs. So I guess I jumped ahead of myself, and I had a slide here, but I didn't read from the slide. So basically, this is permitted under state statute, and there is nothing in our service plan model or policy that would prevent the board from approving a service plan that does authorize the ability for the districts to implement SIDs. The mandatory criteria, again, on your left, and the discretionary criteria on your right, for those in the audience watching that would like to read this. Okay, again, as I mentioned, standard purposes of the district. This district, although it is has been recently rezoned to RR 2.5 last month. This district, although rural residential 2.5 acres, is actually proposing to be a new water provider or a water district. So even though these lots are rural, this district will go through the process with staff in Colorado Department of Public Health and Environment to create a new water district. So prior to the ability for the developer to create a new water district, they have to have a special district created, and that is included in this service plan. And then they will move forward with creating a water district that will serve this development. That will also include water hydrants or fire protective hydrants for the fire protection district. I should mention that this district would allow that if the district isn't approved, then there couldn't be a central water provider because it wouldn't be a public entity, is my understanding. So they kind of play off of each other. At this time, we have not received a formal application for the creation of a district through 1041 because the district hasn't been approved yet through the court system and election. Okay, so I already mentioned that. Unlike the other development, this district, this property now zoned RR 2.5 is surrounded by agricultural 35-acre properties, except for to the west, further to the west, we have some RR 2.5 properties. The district number 1 is an overlapping district. It's about 744 acres. It intends to be essentially an overlay operating district for districts 2 and 3. This will allow districts or residents within the proposed districts 2 and 3 to be elected also to District 1's board to oversee the operations of the district. District number 2, as it is proposed, is about 405 acres. District 3 is roughly 277 acres. The property is actually split into 2 different fire protection districts, so there's separate mill levies here. Staff has met with the developers and the fire protection districts, and it is my understanding moving forward that at the time of preliminary plan, a decision will be made which district they will jump into, so there's only one fire protection district ultimately serving. We have not received the next step, if you will, which would be that preliminary plan. We will consider water sufficiency and utility providers. We anticipate that Black Hills Energy will provide gas, Mountain View Electric will provide electric, of course, and then the new created water district will provide the water, and then individual or on-site sanitation system or septic systems for these lots. Again, large lot residential is our place type, which the board found the property was consistent with at the time of your map amendment from A35 to RR 2.5 last month. And again, just citing that the master plan does identify that development pays for itself. And so staff would recommend that this is consistent with the master plan. The application in summary, the estimated public improvements right now are about $32 million. The applicant is asking for about $37 million. That is not a very large buffer. It is less than what we typically see. And there has been a detailed financial plan provided by Piper Sandler's attached to your staff report packet. Again, same provision applies here and has been incorporated into the service plan, limiting that maturity of overall debt to that 40-year to be compliant with the new state law. And again, each bond can only have a 30-year term. Refinancing is, of course, allowed within the service plan. I should note that there is an adjacent special district, High Plains Metropolitan District, near this property. However, High Plains Metropolitan District didn't necessarily come to fruition in terms of revenue. There were no lots necessarily developed. There is to simplify, there was an issue with water rights, and so there is a lot of water documentation attached to that letter of intent that the applicant has provided to justify the need for this district and to prove how and why they cannot join the High Plains Metropolitan District. It's just not a viable district at this time. Are there any questions from staff other than related to the SID? Because I'm going to defer.
Any questions? Okay, I see none at this time.
Thank you, and I'll ask the applicant to come up.
Thank you.
All right. Well, good morning, board. I appreciate your time today. Thank you very much. My name is Ryan Farr. I'm with went to the old name, Munson, Cummins, Showit & Farr, the legal firm handling the request for the service plan. You've already seen one service plan presentation, so a lot of what I have here is going to mimic that, so I'll kind of be brief on that. I'll focus more on kind of the differences that Ms. Parsons pointed out in this plan versus what you previously heard. So this one is going to be Triple H Metropolitan District 1 through 3, so we have 1, 2, and 3 districts. It's built to be an overlay district and then financing districts, and I'll get into how that kind of works out. The applicant in this case is P760 Land. Legal representation is me. We are using Classic Consulting. NES is helping us with planning, and then underwriting is Piper Sandler, and Mr. Lund is actually here today to be able to answer probably more questions than I'm going to be able to do as well. To start out, this is the site plan, overall site plan. It's on Jones Road, south of Falcon Highway between Murr and Peyton Highway. As Ms. Parsons mentioned, it is surrounded on basically the east and the north of the High Plains Metropolitan District. So it is adjacent to the High Plains Metropolitan District, but as mentioned and provided in the letter of intent, it doesn't make any sense to join into High Plains Metropolitan District to provide for the plan development. I have the criteria for the service plans. These are the must requirements that need to be met in order to be approved. And then the next slide is the may requirements as well that have been posted a couple times that this board has seen. The main purpose of this district, I mean, the main focus of the district and really the big reason for it is the water system. The plan is for the Metro District to develop a water supply system to supply all of the lots, proposed 244 lots. The idea with this is to utilize Denver Basin groundwater underneath the 700 and what comes to about 752 acres actually, but not to use the shallow aquifer that there are a lot of wells already constructed to around the area. We want to use the non-tributary deeper wells in the Arapahoe and the Laramie Fox Hills aquifer, pull those up through central wells and then provide that through a central water system, limiting the impact on the more shallow aquifer and using the less used aquifers underlying the property. Two issues with that, those kinds of wells are actually very expensive just because of the depth they go to. Further, just putting in the entire water supply system itself is a costly endeavor, as well as operation maintenance of that system. So that is the main, being able to do cost-efficient funding through a metropolitan district through the issuance of bonds that are tax exempt and also can see lower interest rates than any private developers can get, which then passes on to the resident by being able to make the houses more affordable rather than having to pay the bigger costs that a private developer would have to get into. Further though, they're not just doing water system, they're going to be building the roads, there's going to be sidewalks, streets, other infrastructure, there's going to be drainage and stormwater as well as parks, as well as a trail system. This is going to be built at kind of 2.5 acre horse-friendly property, and a big plan is to build a trail system through it that people can utilize with their horses. Further, it is, since we are doing additional services and gonna be ongoing continuing services through the metropolitan districts. We are asking to do covenant and a design review as well, as opposed to having a homeowners association. This is the first picture. So this is going to be district number 1. As I mentioned before, this is going to be an overlay district, so it encompasses the entire area. The overlay district is going to be set up as not really the funding entity. It's going to be the operations and management entity. So the overlay district will guide development, guide funding, but at the end of the day, it's going to be the district that manages the water system, manages the drainage system, manages the open space, and will have the mill levies for the operations for that imposed. Districts number 2 and 3 will be financing districts. These districts will not be controlled by the district number 1. They'll just be basically consulted with them. The idea of bringing it into 2 districts for financing is the picture you see here is consistent with the filings and how the phase development that P760 land wants to do with the property. So it allows a little bit more flexibility in bond issuance and financing and development to match what the planned preliminary plan and final plat will be for the development. As you can see, district number 2, and I'll show a further slide that has it, encompasses filings number 1 and 2, and then district number 3 has filings 3, 4, and 5, and that's how and why they're broken up such. All districts are going to be manned. Obviously, district 2, anybody in district 2 who owns property in that can be on that board. Anybody in district 3 can be on that board, and then the entire property, anybody can be on the district 1 board. This is a planned infrastructure map. As you can see on the northern part of the property, that is where the well sites are going to be, along with the tank and the water system itself to provide treatment. We have 2 parks, open spaces in there. This plan does not yet show the trail system that's going through. That's currently being worked out to be developed. It does show the detention ponds on the southern portion of the property up against Jones Road. And then also, it's kind of hard to see at this distance, but you see the roads, and then underlying those roads will be all the water infrastructure and the water pipeline to serve the individual residences. As I mentioned, this is the preliminary plan concept of build out from filings 1 through 5, and how that matches up then with the 2 requested financing districts. So to go through development summary, yes, this is 752.68 acres, I think, after final surveying completed. There is no intention to include other property, since this is pretty much focused on the water underlying its property. There's at this point no thoughts about including additional property to be serviced by the districts in the future. We're looking at a total build out of 244 residences. With 610 residences at 2.5 acres per lot. We plan for absorption of this by 6 years, looking at 2033. All residences will be served by the water system. However, there will not be a wastewater system. So each lot will have its own non-evaporative septic system. As mentioned by Ms. Parsons on the 28th, this board, you approved the rezoning from A35s to RR 2.5s. The total infrastructure cost is estimated at $32 million. Of that, about $29 million of that is district eligible for public improvements, ostensibly kind of removing non-wet utilities that aren't subject to public costs. That's where the 28.8 million is where the 37 million debt limit came from, to kind of balance off about a 15%. So that's where that buffer zone is coming from. It is a little smaller compared to the 32, but we were actually comparing it to that 29 million to get near kind of a 15% buffer. The model that has been provided in the service plan from Piper Sandler has districts financing about 18 million of the construction, and we're assuming about 630,000 value per home. We don't expect to see a lot of differentiation in property values. They're all going to be relatively similar lots and similar builds. So the financial plan, we have debt limit of 37 million is discussed. We're asking for a total mill levy of 65 mills. 50 mils would be for debt service, 10 mils would be for operations. 5 mils would be for the special purposes. This is the covenant enforcement and design review that would occur. There are 3 districts. No district obviously would incur anything more than 65 mils. So they wouldn't be on, compounded on top of each other. We do have an estimated impact down at the bottom. So if we're looking at $630,000 per home, at 65 mils and the 6.8 assessment rate, we would be looking at about $2,700-$2,800 per year in taxes, or $232 per month. Additionally, we are asking for a special improvement district assessment lien bonds to be able to be issued. I would like to note a caveat in the service plan that in order to create these special improvement districts and issue those assessment lien bonds, we would have to come back to you and ask for approval and a specific plan showing exactly what that would be done. So all we're asking approval today is to basically be able to come back to you later in the future when, if that wants to be completed. However, the way that works is these are special assessments lien bonds. So it's a government issued bond to basically help a developer out. So a developer comes and wants to develop a piece of property. They get the bond, the government, the entity, the district to issue these special lien bonds that qualify at lower interest rates, makes it cheaper also for a private entity as well to borrow against, as opposed to private financing, which sees higher interest rates. The developer will then develop those properties. In doing so, a lien is put on every one of those properties while owned by the developer. Once that property gets sold, that lien has to be paid off, thereby never transferring that debt to the property owner themselves. It's a development bond or a developer that has to shoulder that payment. So it never makes it to the owner of the property. As such, it's not included in the 37 million debt cap, and it's not included in any of the mill levies because there's going to be no tax assessment to pay any of those off, since the ultimate homeowner won't see that. And if you do have further questions, again, Mr. Lund from Piper Sandler is here. They are the firm that presented or provided the information packet that Ms. Parsons had forwarded on to you. Keep wanting to go back. Bond structure, this is the same slide you just saw a few minutes ago. Same concept. Plan is to issue the bonds in 2027. They will have 30-year maturity periods, so by 2057 they will mature and be discharged. This early stage bond means there would have to be a market study assessments done to determine whether or not the bonds are worth buying and will be able to be paid off in time. Since there is no track record as such, these are institutional investors only who would be able to purchase these bonds, and those institutional investors also will do their due diligence to make sure the bond buy is smart for them at that time. There is a second issuance projected within the financial plan model to happen in 2037. Again, like the last presentation that you saw, this will be to repay any remaining developer reimbursement obligations that are outstanding and refund any of the 2027 issuances. Those would also be capped at the 30-year maturity rate, and so they would be done by 2067. So what you have is you have both metrics being met. The individual issuance of debt is 30 years only, and then they all get retired off within 40 years to meet statutory requirements, the new statutory requirements. They do get discharged in 2067, no matter the payments that have happened with it. That way it can't carry forward. That way, if there are any issues with build out, if the process sales are slower than were projected, you don't see homeowners down in 2067 getting stuck with more bills because it hasn't been fully paid off. That's a risk that those who buy the debt or buy the bonds face, understanding that it will be discharged by 2067. Same slide, but this one with the Triple H Metro District numbers 1 through 3 to show where it falls in with surrounding metro districts and other just special districts as far as mill levy assessments. There are a couple special justifications in this one. We've talked about the maximum mill levy is 60 mills, and you can add the extra 5 mills for covenants and design review enforcement. In this case, because the district will, or at least District 1, will be continuing services for, in perpetuity to this district, it made sense to also have them control the covenant enforcement and do design review instead of having an HOA. Therefore, they get the extra 5 mils presented to that. Underlying land approvals, this was filed prior to rezoning having occurred. However, as mentioned on August 28th, you approved this property to be rezoned from A35 to RR5s. We are currently planning the preliminary plan to be filed and moving forward then with that process as well. And we wanted to go forward with the Metro District as soon as possible because obviously we're planning on a water system, which is a costly endeavor for any development. And knowing whether or not that's something that was going to be able to be funded through the issuance of public bonds is very important in determining final plans for the actual site itself. So at the end of the day, there is a need for the districts. There is only one potential option, and that's a High Plains Metro District that is, adjacent to this property. There is no development by High Plains at this point. There is actually, there's a private entity called Mid-Colorado Investments that provides water to the Sage Water Users Association, which is a little ways away. However, it's on the same property. There's some easement issues. Mid-Colorado is ironically unfortunately, in bankruptcy right now, and so there's some issues with water provision that they can do and who can use that water. There are no lines built, there are no residences built in High Plains Metro District. At this point, they don't have what my client needs to be able to get the job done, and it doesn't make sense to go to that district. The multiple districts will be helpful to help with the phased development and proper funding of the districts. This is the service plan is submitted pursuant to all the requirements, Special District Act, Land Development Code of El Paso County, meets the model service plan as well as the County Resolution 22376. It also meets the criteria, the must requirements criteria. There is a need. We need homes. This will provide 244 additional single-family residences in El Paso County in the growing community. At reasonable prices, very average rate for what they are, modeling around $630,000 per lot with a house. There is need for the district to provide these services. We're going to be providing water. We're going to limit the amount of small wells within the Denver aquifer and go to the deeper aquifers. Plus, we'll be able to provide consistent water supply, consistent quality water to all 244 residences. It also helps with the fire protection. We can provide hydrants and then back that up necessary with cisterns as well if needed. We can do it as shown by the financial plan that was submitted with the board. It can be done financially. It's financially able to be done and discharged. The indebtedness in the required amount of time and not in any overly onerous way on homeowners. It actually, by doing the bonding and taxing, it actually makes lots overall cheaper than what you'd have to do if you had to buy from a privately funded enterprise. Anyway, that is all I have on the Triple H Metro Districts 1 through 3. If you have any questions, please let me know.
Commissioner Weisong?
Thank you, Madam Chair. A couple of questions. First one on the Special Improvement District. You were talking about a lien on the property, which helps the developer get, I guess, best way to claim it, cheaper money. But there's a lien placed on each individual lot. Is that correct?
Commissioner, maybe at this time it might be best to have Mr. Lund come up and explain this in more detail and better than I can, if
Sure.
you allow.
Michael Lund with Piper Sandler, and we prepared the financial model for this service plan and also worked to discuss the special improvement district. I'll say yes, it is imposed on, there's an assessment placed on each individual lot. Now, sometimes before it's subdivided, maybe it could be at the parcel level. But as it gets subdivided, we have mechanisms to end up on each individual lot. But that assessment, not per se statute, but per the way we structure the bond deal and then the service plan for what it allows, has to be cleared before it goes to an end user. So that way a homeowner never sees it. So you might say, well, okay, why does the developer need it then? Currently, if they didn't have this tool, they would typically use the land as leverage to go out and fund some of the initial infrastructure. They might go to a bank that might require the property as collateral, or equity investors that require the property as collateral. So it's kind of similar to an assessment, just a different mechanism. Well, the bank or the equity, their cost of capital through that mechanism is probably 12 to 15, 20%. Since we're doing the special assessments in a well-established municipal market, they can go out and go to institutional investors in the municipal marketplace. It's tax exempt. The cost of that capital is somewhere between 5 and 7%. So a much lower cost of capital for using the same land as security with just a slightly different mechanism.
Okay, it was alluded that once the home was built and then transferred or sold, then the developer would pay off the property. What about if a homeowner or a potential homeowner just wanted to buy the lot and have their own builder? So at that point, the developer would have to pay off the debt on that particular lot, correct?
Yes, correct. Because it's not necessarily tied to a home being completed. It's really the transfer of that property to an end user. So whether it's a vacant lot or a home that's completed, to your point, yes, correct. It would have to be cleared from that title before it could be transferred to what we call an end user.
Okay. Question 2, and it kind of goes back to the 40-year time frame. In the first 10 years on a bond, are you paying off any of the principal?
Yes, typically it does start to amortize around year 3 to year 5, depending on the growth and the projected build out. But yes, it does start to amortize.
So when you refi, hopefully you're going to refi for a lower interest rate, and whatever the balance is there a opportunity to, when you refi, to go all the way up to the maximum dollar amount of the original bond? So let's say you took, let's see, what was it, 37 million on this one? 32? And so let's say you paid it down to 28. Can you, when you refi, are you allowed to go back to the full 32 million?
Yeah, no, that's a great question. And it depends on the Tabor election, which would probably allow for that as well. But yes, they can, as long as they can go back up to pay for, if there's additional developer reimbursements that are still outstanding, they could increase the size to go back to repay some of those. But that, quite frankly, at that time, it's probably a homeowner board when you get out that far, because the district's probably built out. And so the homeowners would do that analysis, whether it makes sense to basically add to their debt to pay off the developer reimbursements or to just keep paying the developer reimbursements separately. And so you also asked about a lower interest rate. Once the district is built out, it's a much better credit profile. So yes, typically, depending on where the interest rate environment is, but typically you're able to lower the rates quite a bit.
Okay, thank you.
Yep.
Commissioner Nelson.
I have a question on slide 15. It says that it's zoned RR5, but these are 2.5 acre lots. Am I missing something? Do we need to do it?
Oh, I apologize. That's a typo. That should have been 2.5.
Okay.
My fault. Sorry.
Great. I was like, are you guys coming back to rezone?
No.
All right. And then on slide 11, we'll work backwards. Can you talk me through the bullet points where it says the total infrastructure costs are 32 million, but only we'll just round 29 million are eligible for public improvement costs? And is it then the mills that are assigned to the homes based on that 29 million? Or is it based on the 32?
Well, the mill levy that will be issued would be, for this debt, would be the 50 mils. So it'd be the max 50 mils to repay it. What this is showing here is, so right now our projected total cost for development of this project is 32 million. That includes a couple things that aren't allowed to be publicly funded. Black Hills Electric, gas, you can't publicly fund those private entities to put those lines in. So those things are actually pulled out of what can be publicly funded. And so the 32 million is the whole project, and then the 28.8 million includes what can be funded through the issuance of bonds.
So the developer will cover the extra 3 million themselves then?
Yeah, and that
essentially?
works between the energy company, gas company, and the
Okay.
developer, and on how that cost gets covered.
Okay,
Yes.
thank you.
Okay, any more questions for the applicant? All right, seeing none, I think we'll just make sure that there is nothing else that you all want to add.
No, Chair, thank you.
Okay. Do we have anything that staff needs to add? Okay, with that, we can move to the public input portion of the process. So we will again begin with those who are here in support of this application. Do we have anyone here who wishes to speak in support? And I see no one coming forward in the room, and we have no one online. So we will move to those who are here to speak in opposition. If you are here to speak in opposition to this application, if you would come forward at this time. And I see no one in the room and no one online. So again, this is typically the time for rebuttal, but you don't have anything here to rebut unless there's anything that you'd like to add at this time. Thank you. So we will ask if there are any additional questions for staff this time. Okay, with that, we'll declare this public hearing closed and we will bring it up here for any discussion or motions. Commissioner Weissong.
Thank you, Madam Chair. Just curiosity, do we need to make any kind of amendment since there was a correction on slide 15, even though the actual requirement does show RR 2.5?
Yeah, no, as long as the actual resolution is correct,
Okay.
we don't need to correct the presentation.
Okay, thank
But
you.
thank you for the question. Okay, I'll just add a brief comment since this is in my district, that I appreciate the presentation and I appreciate you bringing up in particular the difference between the aquifers and utilizing that deep water well that does help to protect some of those that are on those more shallow aquifers. So water is such a complicated topic and that's it, but it's one that's very important to me. So appreciate that. And with that, I'll just ask if there is a motion from the commission.
I'll make a motion to approve the special district service plan for Triple H metropolitan districts numbers 1 through 3.
Second.
Okay, that's been moved and seconded. I'll check for any last minute comments. And I'll call the roll. Commissioner Weissong,
Aye.
Commissioner Nelson,
Aye.
Commissioner Applegate,
Aye.
and the chair votes aye. That passes 4-0. Thank you. Okay, before we move on to item 8, we are going to take a brief comfort break. So we'll be back in about 10 minutes. Okay, I'll call this meeting back to order, and we are on item 8.
Item number 8 is a special district service plan, Wilshire Metropolitan District numbers 1 and 2, a request from Isinogle Seaver Pogue PC for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for the Wilshire Metropolitan District numbers 1 and 2. The 50.78 acre area included with the request is zoned PUD, planned unit development, and is located immediately west of Mark Shuffle Road and south of Constitution Avenue. The service plan includes the following: a maximum debt authorization of 20 million, a debt service mill levy of 50 mills for residential and commercial, and an operations and maintenance mill levy of 10 mills and 5 mills for special purpose, for a total maximum combined mill levy of 65 mills. Covenant enforcement is requested. The Planning Commission recommended approval 5-0. There is public opposition to the request. Parcel numbers 54050 00060, 54054 10001, 54050 00059, and 045. Commissioner District Number 2, File ID 25005, Carrie Parsons, Principal Planner, Planning and Community Development.
All right, good afternoon. Carrie Parsons, Planning and Community Development. This is for the Wilshire Metropolitan District numbers 1 and 2. For the record, the opposition has sent a withdrawal of opposition letter to the chair. That letter and documentation, I believe, has been distributed as of yesterday to the rest of the board members, and the party is now moving more towards a neutral, so not quite in support, not quite in opposition, and they are still here to, or they are here to speak today on the item. If there are any of those in the audience or watching remotely and you would like to participate, if you could please email pcdhearings@elpasoco.com and we will get you in the queue for this item. Again, hearing procedures, the same for this item as those before it. And just hold for 3 seconds on this in case anybody's watching remotely. All right, thank you, Ms. Allard, for reading the request into the record. More specifically, this request is for the $20 million. Again, the 50 mills is for both the residential and the commercial district, and both districts would have the 10 mills for ownership and maintenance with 5 mills for special purpose. For covenant enforcement, there is no SID associated with this application, and the applicant does state in their service plan executive summary that they would have the ability to assess fees if necessary, but not necessarily anticipated to do so. Mandatory criteria for disapproval and discretionary criteria on your screen. Again, I'm going to hold for 3 seconds for those watching if they wanted to review this. Standard purposes, statutory purposes are requested with this service plan. History on this project. This project goes back a couple decades. So this area was zoned planned unit development in 2004. At the same time, there was an approved preliminary plan for a portion of this development approved by the Board of County Commissioners. A portion of this service plan, District Number 1, as requested, is within the Constitution Heights Metropolitan District. I should note that that has officially been, the resolution for order for exclusion had been approved, and I believe yesterday received a final copy of that exclusion order, which has been uploaded to the public record file. District Number 1, if created, will still be responsible to pay off the fair proportionate debt accumulated by CMHD. And so you're going to notice in a later slide a difference in mill levies. So again, the planned unit development for Wilshire here. Lost my mousey. And just kind of giving you a more specific layout because we have one here with the being a public or planned unit development. So this area here would be within district number 1, and here is the actual approved preliminary plan layout for that. Colorado Tech Drive will be constructed, designed by these two districts, and ultimately turned over to the county as public right-of-way for ownership and maintenance. There is also the Sand Creek drainage channel that goes through. Of course, in the 20 years, this channel may have meandered, so it may not be exactly where it was depicted 20 years ago, just for the record. I do want to point out the folks that spoke at the Planning Commission, known as the Raleigh family. This is one of the properties of concern in this area, and then further to the south off the screen. I'm going to insert here the discussions at the Planning Commission at the time were identified as opposition, concerned the statements that the applicant did not work with the Raleighs to allow the Raleighs to participate in this service plan. Additionally, there were concerns brought up that there was not a mutual relationship in the design of the Sand Creek Channel. Both parties would eventually be responsible to design and construct, stabilize the Sand Creek Channel as it relates to adjacency to their properties. And the applicant will speak to that as well as, I believe, Ms. Richter. This slide demonstrates that the mill levy for District 1 is higher because it's going to continue to include the debt in fair proportionate share payoff of the Constitution Heights Metropolitan District. Again, master plan, this type is urban residential place type. So this development being already zoned PUD is consistent with the place type, and the development pays for itself of our master plan. In general, summary of the application. The applicant has included in the service plan the new statutory language limiting that 40-year overall debt, and we anticipate refinancing of the bonds at 10 years, again meeting that 30-year term for each bond with that tenure for no more than 40 years. CSU will be providing gas. It's in their service area. Mountain View Electric will provide services, and Cherokee Metropolitan District will provide water and wastewater to this development. Are there any questions for staff as it relates to that? And with the chair's permission, I wanted to jump into just general discussion for some of the code-related concerns that were brought up in terms of not really opposition anymore, kind of more neutral. So in terms of design considerations, when the applicant moves forward with final platting, their property, staff and DPW staff and PCD staff will be reviewing the construction drawings and drainage plan, as well as a drainage report to ensure that the applicant is meeting the criteria of the engineering criteria manual, drainage criteria manual, and the land development code. Additionally, the land development code ensures that road connectivity is provided through properties, whether it's an easement, future right-of-way dedication, so we don't landlock parties. So what I mean by that is, I'm going to jump back to the zoning map. The parties down in this area, as you can see, would be difficult time to get access from the west if we didn't require this developer or this developer to bring that road at a stub out, because Mark Shuffle Road would have limited access being a principal arterial. So our land development code does ensure at the preliminary plan and then at final plat that staff does look at that and make sure that we are not landlocking that. And then additionally, there are guidelines in both the Land Development Code and the drainage, the ECM and drainage criteria manual that required that we do look at drainage concepts and ensure that we're not disproportionately putting the burden on the Raleigh family versus the current applicant, Mr. Langdon. So I just wanted to put that on the record in the PowerPoint in case there was any questions that may come up when Ms. Ingrid speaks and Mr. Dossi speaks. That would conclude staff's presentation if there are no further questions. Oh, I should add, I'm sorry, Chair, one further. We do have in our policies that we discourage a proliferation of special districts. And so that being said, the applicant and the Raleigh family working together would have been in support to limit an additional district being presented to this board in terms of a new service plan, but there is nothing that would prohibit in the future the applicants working together to come back and amend the Wilshire service plan to create a third district to incorporate the Raleigh family. So I wanted to put that out there too for the record. Any questions on that?
Looks like done at this time.
I know, it switches, it's hard. Thank you. Hello again, Alicia Corley here on behalf of the applicant for Wilshire Metropolitan District number 1 and 2. As I mentioned previously in our prior presentation, we have representatives of the developer and financial team and planner here as well. Carrie showed you a vicinity map. This just details the district number 1 and district number 2, where those would be located off of Mark Scheffel and Constitution Avenue. This is a 50-acre parcel zone PUD. As Carrie mentioned, the preliminary plan has been approved for district number 1 for 44 single lots, and it's anticipated that district number 1 would include an additional 270 single-family residences. District number 2 would be planned for commercial development of 55,000 square feet. As with the other district that I was here before you today, we would have this public hearing, an election in November, and then formation of the 2 districts before the end of the year. This shows the infrastructure that would be put in by these districts: water, sewer, roads, open space, landscaping, and drainage. As Carrie had mentioned, this property is located within Cherokee Metropolitan District, and by law, we are required to obtain the consent of Cherokee Metropolitan District in order to form this Metropolitan District, since there are overlapping boundaries, and that consent was obtained by Cherokee Metropolitan District. Wilshire Metropolitan District 1 and 2 will construct the water and sewer facilities, pay for those water and sewer facilities, and then turn them over to Cherokee for future operation and maintenance. Carrie had also mentioned that part of the district here, Wilshire Metropolitan District number 1, is located within Constitution Heights Metropolitan District, and she is correct that that property has been excluded from Constitution Heights Metropolitan District. They adopted a resolution quite some time ago, but in order for it to actually be effective, we have to get an order from the court and it has to be recorded, and that has taken place since the original service plan was filed. So the property that will comprise Wilshire Metropolitan District number 1 is no longer located within Constitution Heights, but as Carrie mentioned, and this is required by law, that property will be responsible for paying its proportionate share of the debt that Constitution Heights has already incurred. This is the same slide that you saw previously. So again, explaining the use and utility for Title 32 special districts, where the residents and property owners within these districts will pay for the infrastructure and then ongoing maintenance that is needed, rather than it being funded by the county, which allows for access to longer term funding at lower interest rates for these residents and property owners. This district will construct a number of public improvements and then have ongoing maintenance responsibilities. They'll construct water and sewer facilities, roadway improvements, drainage facilities, open space and landscaping. They'll be responsible for covenant enforcement, and that's the purpose of the special purpose mill levy. And then there'll be ongoing operation and maintenance responsibilities for any non-dedicated streets, the drainage channels, the 4 detention water quality ponds, and open space and landscaping. Again, our service plan meets the county's model service plan. We meet the criteria in the statute, and staff had no outstanding concerns regarding the formation of these special districts. The debt limitation that's asked for today is $20 million. That's based on estimated public improvement costs of $16 million. And again, there is a cushion to allow for inflation, contingencies, and changes that may occur from the time of approval of this service plan until the improvements are actually constructed. Carrie had gone over this as well. The maximum mill levies, 50 mills for debt, 10 for O&M, 5 for special purpose, for a total of 65 mills, and this is correct in the service plan. We have the same service plan limitations here, so you'll have your disclosure to purchasers that's required, an annual report that's filed every year, and this is especially important in this scenario, that the development remains subject to land use approval. So you today, in approving a service plan, are not approving the underlying land use. That will go through a separate process. Again, we have the same language that's included in our other service plan of a 40-year debt mill levy imposition term, and that is in addition to the language that was already in the county's model service plan for a 30-year maximum period of debt. These are the 4 criteria that we have satisfied today for approval of this service plan. The need, there's a demand for commercial development and housing in this area, and especially important here that the districts will be able to construct and fund these public improvements that another entity cannot construct, and then continued maintenance of those public improvements along with covenant enforcement. The second criteria is that the district will be serving present and future projected needs. There are currently no other governmental entities that are able to construct, fund, and then maintain these improvements here. It's been excluded from Constitution Heights. They're not capable of providing the services. And then the water and sewer facilities have to be constructed and funded by these Wilshire metropolitan districts and then turned over to Cherokee. And these districts will provide the funding for the initial construction and then ongoing maintenance. Third criteria that we meet, the proposed special districts are capable of providing economic and sufficient service. Again, I have a slide that shows you where the mill levies are compared to other districts in the area. And then here, as our previous district, these districts will provide continued maintenance of the public improvements that are being constructed. And this is the slide that I mentioned that shows where Wilshire Metropolitan District falls compared to other districts in the area. And the last criterion, the district has the ability, or districts, excuse me here, because there's 2, have the financial ability to discharge the debt, and that's demonstrated by the financial plan, which we have attached to the service plan. And we also have a slide which details the bond structure. Again, we're anticipating an initial bond issuance in 2026 with a 30-year term, final maturity. Again, you would have those same requirements of a market study and financial forecast and issuance of the bonds to institutional investors, and then followed by a refinancing anticipated in 2036. And again, Mr. Lund is here should you have additional questions regarding the financial plan, which I cannot answer. We are asking for approval today, and then we'll go to the court for an order for an election in November, and then seek an order from the court forming the districts before the end of the year. And I am happy to answer any questions that the commissioners may have.
Any questions from commissioners this time? Commissioner Applewhite?
Maybe I missed this, but what was the zone? What was that area zoned for currently?
PUD.
PUD.
Yes,
Okay.
sir.
Okay. Thank you.
Okay, it doesn't look like we have any more questions
Okay.
at this time.
Thank you.
So we will move to the public input. I'll just make sure before we do that, though, we don't have any questions of staff after that presentation. Okay. So we'll move to public input, and we will begin with those who are in support of this application. So if you are here to speak in support of the application, I'd ask you to come forward at this time.
Madam Chair, Commissioners, thank you for the opportunity to present on this project today. We originally filed a letter of opposition. We are withdrawing that. Given I did not know when to speak, I'm just going to go ahead now if you're okay with that. My name is Ingrid Richter. I'm a broker and managing director of Olive Real Estate Group, appearing on behalf of the Rowley family, who owns approximately 60 acres of I-3 zoned property to both the east and the south of the Wilshire Metro District. I serve the Rowleys as a real estate advisor and development consultant. I do not have any financial interest in the property. That appeared to be a question at Planning Commission, so I just wanted to clear that up. I'm here today to acknowledge the Rowleys' withdrawal of opposition to the Wilshire Metro District application. This decision reflects a cautious optimism that a viable financing mechanism is finally emerging to address longstanding infrastructure challenges along the Mark Shuffle corridor. It's also extended as a gesture of good faith to encourage renewed collaboration with the applicant. To be clear, the Rowleys have never opposed coordinated infrastructure delivery, but they are business owners, not developers, although they are learning the development process the hard way. Unfortunately, their property has endured decades of flooding and limited access due to incomplete roads and underperforming drainage systems, stemming from various agreements associated with the surrounding residential encroachment to include multiple Wilshire Ranch plat approvals and the Constitution Heights Metro District. Unfortunately, the parties' timelines for entitling and developing their respective properties have diverged, and the applicant is significantly farther along in his efforts. Looking forward, the Rowleys intend to initiate a sketch plan to transition their property into a shovel-ready employment center consistent with the El Paso County Master Plan, or to respond to the current and emerging market demand for industrial development in the county. A draft sketch plan has been shared with the applicant and the county staff in advance of this hearing, offering an opportunity for input and coordination. Since that time, Mr. Langdon has reached out, and we've actually scheduled a meeting with both project teams for next week, so we're very encouraged about that. However, we are here today to place two items on the record that Carrie Parsons did mention. First, once Colorado Tech Drive is constructed and accepted by the county, it becomes public right-of-way. Accordingly, bless you. Accordingly, Colorado Tech Drive and any future feeder roads must provide appropriate access to the Rowley property to support both its current operations and its intended future uses. We believe access should be determined through county review and policy, not through private negotiations, ensuring equitable and transparent infrastructure planning. Otherwise, I fear there may be a quid pro quo leverage that would derail communications, and I don't want to see that happen. Secondly, given the complexity of the site and the county's current Metro District policy framework, the Rowley family respectfully requests your support to pursue a separate Metro District or amend this Metro District tailored to the configuration and infrastructure needs of their property. Their intent is not to create fragmentation, but to align with the infrastructure delivery reflected in the application before you. They're hopeful the Wilshire Metro District will serve as a meaningful solution for the long overdue infrastructure needs in the corridor, provided the proposed improvements are implemented as envisioned and coordination in good faith continues. Thank you for your time, your consideration, and your service to the residents and business owners of El Paso County.
Thank you. Okay. Do we have anyone else who'd like to speak in support of this application? So I see none in the room and none online. We'll move to opposition. Is there anyone here who wishes to speak in opposition to this application? And again, we have no one else in the room and no one online. Okay. At this time, this is normally the rebuttal portion. Again, we didn't really have anyone in opposition, but I'll ask if you'd like to add anything else at this time. All right. No. Okay. Okay. With that, I'll just ask, yes, Commissioner, for staff. Okay. So we do have a question for staff. Commissioner Weissong.
Thank you, Madam Chair. Could we pull up the extra exhibits that were behind the staff presentation?
Yes. Sorry, I wasn't sure if you meant the staff report packet or my hidden slides. I'm happy to do that.
We can all lean to the right. The lighter blue line, could you explain what that one is?
Are you talking about this line, sir?
That is correct, yeah.
I'm going to just verify with the county engineer before I speak, because I don't want to get it wrong.
Might be. I'll have to look into this one for you. I haven't really seen this exhibit. So.
If you could just identify
I'll have to
yourself
get
for the
back.
record, please.
Oh, sorry. Gilbert LaForce, Deputy County Engineer. So if I can get back to you on that one, I need to go double check this.
Okay,
exhibit.
it was a curiosity question, but while you're there, then I'm going to assume the darker blue line is some of the flooding and the meandering channel for Sand Creek. Is that correct?
Yes, sir.
Okay. So then the next slide. It looks as though that you're going to, or someone is going to channelize Sand Creek. And then that's where I think some of the concern was, is now Sand Creek is just going to end at the Raleigh property. And in reading some of the extra information that was attached, you know, which is, I'm not sure where these were anymore. There was some debate back and forth. Seems as though that when that gets channelized, there's going to be a whole heck of a lot more flow of water. And I don't see a retention pond there at the property line, so it's just going to funnel straight into the Raleigh property. And so I'm just, you know, this is getting in the weeds, but, and this could be something that's taken care of further down the road, but being that the information that was added about some of the concerns of drainage, I don't see a solution yet. And if that's going to be taken care of down the road during the subsequent approvals, I'm good with that. But I just wanted to address it, that I just didn't see anything, and I didn't want this to all of a sudden to be an issue down the road.
Yes, sir. It's going to be done at the next stages. So during the early assistance, we've identified that we're going to need a master development drainage plan that looks at more of the bigger picture impact. And then down the road after that, we'll get that refined to what they're actually going to be obligated to also improve themselves. So there has been a lot of different drainage changes to this area. So that's why we're going to ask for that MDDP.
Okay, I'm good with that. Thank you.
Okay, are there other questions for staff at this time? Okay, seeing none, we will close the public hearing and I will bring it up here for any discussion or a motion.
If you're ready for a motion. Motion to approve special district service plan for Wilshire Metropolitan District number 1 and 2.
Second.
Okay, that has been moved and seconded. I'll just check one more time for any additional comments. All right, we're ready to proceed with the vote, beginning with Commissioner Weissong,
Aye.
Commissioner Nelson,
Aye.
Commissioner Applegate,
Aye.
and the chair votes aye. That passes 4-0. Item 9.
Item number 9 is department and committee reports, non-action items, and there are none.
Item 10.
Item number 10 is the addendum, and there are no addendums today.
Item 11.
Item 11 is the executive session, and there is no request for executive session.
With that, we've come to the end of this agenda, and this meeting is adjourned.